everybody. Welcome to the PT workshop for today. This is the one PT workshop I'm doing that's like a big free one for the upcoming February 2025 exam. I will be doing one more free workshop. I actually have two more that are scheduled. One in very early February and another one shortly thereafter, where I'm going to talk just for California people and just tips for each section for doing the exam remotely. So I'm going to talk about that, talk about the schedule and the timing and what to expect. So look for an email in the coming weeks, coming week or so, 2 weeks, with an invite for that I'm just doing special. I wouldn't normally do it, but I'm doing it just for California folks who are taking the exam remotely or with the new conditions. So be on the lookout. But first, my name is Maureen. I am the founder and creator of BarMD. We're a full service bar prep company. So we offer everything for the bar exam, for the multiple choice, for the essays, for the performance tests, anything that you might need. We have stuff to help memorize. I've written books and classes and all sorts of stuff. And not just for California, for other states too. So if you need to take another state, we've got you covered there too. But tonight we are going to talk about the performance test. And I'm going to walk you through the PT. I'm going to walk you through the process for the performance test. And then I'm going to just kind of walk through deconstructing some of the materials in the file and in the library. And particularly, I'm going to do it. I'm going to do it without highlighting. So I'm going to do it just with like annotating, just in case for whatever reason you can't highlight or mark up in the materials at all, which I just really I doubt, because it's so important and because you're taking it remotely. So fingers crossed that we're going to have the highlight feature. I know that it has the multiple highlight color capability within the Measure Learning platform. So just fingers crossed that they do that. And also, as a heads up, as a thank you for everybody that's coming live, we do have a special promo that we're going to be doing that I'll give out at the end of this session. So hang out for that too. All right, so let's get into it. Let's get this going. And yes, you will be able to use the whiteboard for both the written portion and in the essay portion. I'm sorry, the written portion and the multiple choice portion. Today, we're going to talk about understanding the process for approaching a PT. Even if you've seen me do this in other videos, or if you're in my class or anywhere else, or if you have my book, it's still oftentimes people get a new little nugget each time I go through it, which is why I do it so much. I'm going to talk about how the PT is put together and talk about how to organize a PT a bit. So let's get into it. But first, I'm going to just talk about some tools, tools for prep for the PT. So first, if you haven't started prepping for the PT before and you don't really feel comfortable with the PT, it's definitely not too late to start doing the PT course. We give you a schedule and we give you PTs. There's lectures that you can do, etc. The lectures that you can watch on demand that are great. There's also this Sunday, we have a checkup. It's the PT checkup. And what these sessions are, it's $25. And what you do, we do them for like basically every week, but some are for the essays, some are for the PTs. So on Sunday, which I keep wanting to say tomorrow, but today is Tuesday, I think. But we're going to do the checkup this Sunday. It starts at 1 p.m. Pacific, 4 p.m. Eastern. So it's at 1 p.m. Pacific. You're going to join. There's going to be a little hubbub in the beginning where, we're getting people set up, which is true when you take the exam also. And then it's a proctored session, and you're going to do 2 PTs. So I know that, on the exam, you're only going to have one, but we're going to give you 2 PTs, and it's going to be timed and proctored, and it's going to be really good practice. And then afterwards, I'm going to teach you what you should have done. I'm going to walk you through the 2 PTs that you are going to do. For those of you that are in the classes, they are assigned later in the course, so you're going to knock some out. And even if you've done them before, it's still good to do them again. And it's also not one that is going to be on the mock exam. So we've thought about all that stuff. And then also, finally, if you don't have my book, the book is another really good resource. And The book is really good to complement the course as well. It's like, a course, and then you also have the textbook to go along with it. So I'll put the link to this in the chat also. Oh, I just realized I wasn't sending these to everyone. So there's that. And then here's the checkup. It's checkup 3 that you want to join, just as a heads up. It's checkup 3. And there is the course. And Sam, I'm not sure what you're referring to, but the info for today's session. But we're going to send out a recording of this tomorrow too. Okay, so let's get into, oh, yes, thank you, Sam. That's what you need. Also, the PT that we're going to do today, the PT that we are going to do today is State v. Hughes. So that's the one that we're going to look at. I just put the link in the chat. I'm also going to drop the actual PDF in the chat. So everybody should be able to click on the PT, but you can also just follow along with me. You can just follow along with me as well right now. So generally speaking, also, if you do the PT checkups, we don't send out reminder emails. We don't send out the link. The links will be to join the live checkups. The links are posted in the course portal. They're posted there generally with like 48 hours in advance. I'm going to check tomorrow and make sure everything is in there. Actually, probably check it tonight. So just as a heads up that those will be there. We don't send out email reminders, and we don't send out the Zoom link because I don't want it to be shared. So, all right, let's get into the PT process. Let's talk about it. So the first thing that you're going to do is that first document in the file is your task memo, the first substantive document, I should say. So you're going to review the task memo. And when you review the task memo, you should identify 5 things, right? 5 things. One is the tone, which is it objective or persuasive? Very rarely, but sometimes they will give you a task. They have not done this in quite a long time, but they will give you a task where there's an objective component and a persuasive component. So it's really like 2 little mini tasks in there, but that's rare. So the first thing you're going to do is you're going to identify the tone. The second thing is the audience. You're going to identify the audience. Who are you writing to? Are you writing to the court? Are you writing to a client? Are you writing to opposing counsel? Those are generally the people that you write to. All right, so tone, audience, then what is the product? What is the product? Oh, somebody said they can't get the link to work. What is the product? So there are 5 very common tasks that you can be told to prepare. So the 5 are an objective memo, or just a memo, which is usually something you're writing to your boss. So an objective memo. The other common objective task is a letter to your client. So a letter. And then there's 3 common persuasive tasks. There can be a closing argument. So, I think they've done like 3 of these in the last 6 or 7 years, 8 years. So it's not the most common, but it's fairly common. They've done it 3 or 4 times. So you could have a closing argument. You could have writing a brief, or the argument section of a brief, or you could be writing a component of, this falls in the brief category, but like a memorandum of points and authorities in support of a motion. Those are really structured identically. And really, they're basically the same thing for the purposes of the performance test. The reason I mention it is because people get confused when it says memorandum of points and authorities, because they see the word memo and then they think it's objective. But a memorandum of points and authorities is a persuasive document. So you're writing to the court. So a closing argument, a brief or memorandum of points and authorities, and the third common persuasive task is a letter to opposing counsel. So those are the 3 very common tasks that are persuasive. So the 5: memo, letter to a client, letter to opposing counsel, brief or memorandum of points and authorities, closing argument. All right. So tone, audience, product, organization. So this is really with the meat of your PT. How are you organizing it? What are your subheadings that you have under the analysis or the argument section? So what are the headings that you have there? Ideally, they'll give it to you in the task memo, but they don't always. Often when they don't give it to you, in my experience, when they don't give you the issues in the task memo or tell you what to argue, then often the organization is going to come from the library. For a lot of people, they get freaked out when this happens. Anybody else? Anybody get like nervous when they don't just tell you, I want you to argue 1, 2, 3? Tell me in the chat. Yeah. Oh, hey, Bobby. Hey, Stella, welcome back. Yeah. So for most people, people get really nervous. Oh, hey, Maria. Get really nervous. And sometimes it's just like, what do I do? How do I organize it? The one we're going to look at today, it ends up being a little bit easier, but generally it comes from the library, and you just have to do what they tell you to do or you basically just have to follow what they do in the library. So if they give you one case that deals with one issue, another case deals with another issue, a third case deals with a third issue, you just have a section dealing with each issue. So that's each issue raised by the library. So the organization. Sometimes they'll say you're going to respond to a letter. And when you respond to the letter, you're going to look at, well, what are the points that they raise in the letter? Or what are the points if you're responding to a motion or a brief? What are the points that they raise? And you're going to just use those as your headings, as your organization. Then the last thing that you look for is any special instructions. If they tell you you need to write a statement of facts, if they tell you you don't need to write a statement of facts, if they tell you to address a certain issue, etc. So those are the 5 things. So tone, audience, product, organization, and special instructions. The PT checkup on Sunday starts at 1 p.m. Pacific time. All right. So after you go through the task memo, you should also, just as a heads up, I'm going to say this too, and I might modify what I teach, but you should also identify who your client is. Like, what side are you on? I've just seen enough people make a mistake. It doesn't happen often, but don't be the person that ends up arguing the wrong side. So that's all. So like, make note of who your client is. And I would just say to like jot that down in your notes somewhere. And you might, if you have your white erase board, and I have mine, it's on my kitchen table, but if you have your white erase board, you might make note of that stuff, just sort of like the main points on your white erase board too. But most of the time with the performance test, I'm not using like a little notes document. You know, you have like a notes option in Measure Learning or a white erase board or anything like that. Or like when we did it in person, you had scratch paper. I don't use it. I just type directly into the exam answer. All right. Once we've done the task memo, we've identified those 5 things plus who's your client. Then I want you to do the setup in your Word doc. So you're just going to draft very quickly an introduction that is 1 sentence, usually, that just says, you know, basically it varies based on the task. I have templates of all of these in my book and in the course, but basically just saying like what you're supposed to do. And then you're going to put in your headings to the extent that you have them, if you were given them, and then you're going to put in a conclusion. And again, you're going to just throw in like a quick 1 sentence conclusion. You might expand on that later, but just right now, just have something in there. Just in case like you run out of time at the end, I just want you to like really look complete. So you're going to set it up. It's going to be hopefully pretty straightforward. Then you're going to skim the file. I'm going to do this with y'all a little bit today, but you're going to skim the file. Then you're going to skim and read the library. And I'm going to walk you through this. But the main thing is, 1, if you don't know what the organization is yet, you want to figure that out. So that is like, if you don't know what your subheadings are under your analysis or your argument heading, you know, your next objective is to figure that out. So for example, I'm just getting a blank doc open. So for example, if I have introduction, analysis, conclusion, you know, I would have just a quick introduction. I want to figure out, you know, issue 1, issue 2. I want to know what these headings are. What is issue 1? What is issue 2? So that's what I'm trying to figure out, is what are these headings? And just as a little bit of an aside, this is the basic setup for any PT. Like, you know, sometimes like I talked to somebody today who they're like, oh, I was told to do a closing argument. I just thought a closing argument was something that was short. So they're like, you know, what they wrote was very short because they thought that realistically that's what it would be. A PT is a PT is a PT. They basically all consist of these things. And for every issue that you deal with, you're going to basically have a rule, or you could have all of these things. So for each issue, you could have a rule of proof. You're going to have analysis. It's usually several analysis paragraphs, potentially a counter argument and a conclusion. I go in depth on on rule proofs in my course and in my book. It's something that's a little bit complex and requires, it's really not that tough once you get it, but it usually takes me a little bit of time to teach it, and I'm not going to go in depth on that here. But I do go in depth into it in other places, so you can definitely check that stuff out. But you're going to have a paragraph of rules, the rules you just get from the library. Then you're going to have a rule proof. All this is saying, what did in the case in the library, so let's say it's Smith, what did the court in Smith hold with respect to this issue that we're dealing with? How did they apply these rules to the parties in the case? So why, did the court say, if the court was analyzing whether the evidence was admissible for impeachment, if that's the issue that they're analyzing, then you're going to give the rules for impeachment here, and then for the admissibility of the impeachment. And then your rule proof is going to say, in Smith, the court held the evidence was or was not admissible to impeach, and why. What facts and reasoning did they use? What did they focus on? And the reason this is important is because we are going to have facts or not have facts of a similar nature in our file. So we need to be able to say, okay, our case is just like Smith or it's not like Smith. When I'm writing the analysis, when I get here, I am going to apply the rules, and I'm going to show this is really how you prove a case. We don't ever want to just argue and apply the law to the facts. Like, we want to strengthen this by using case law to say our case is just like that case. And in that case, we have the same type of facts. And in that case, they came to this conclusion. And you have to follow what the court does, right? This is binding authority. So you have to follow what the other court says. And this is what the court says in that case. Our case is just like that. Or it's the opposite. And therefore, you have to hold the opposite. Yes, Anita. Yes. By issue, I mean the question that they give you in the PT, whatever that issue is. I just use generic terminology here because I'm speaking broadly. I'm not giving you specific issues. And we're going to talk about it. I'm going to get a little bit more in detail into it in a minute. So you're going to put in the rules. You're just going to copy these from the library. You're not going to try to change them. You're going to draft a rule proof. You're going to write your analysis, usually several paragraphs of analysis. Not for every issue, but at least one issue in your PT, and ideally two. You're going to have a counter argument. And then a conclusion. And these are each separate paragraphs. And it's probably going to look something more like this. And rule proof, analysis, counter argument, which is theoretically, it actually is analysis, and then a conclusion. Okay. Yeah, the rule proof is the holding as it relates to this issue. Polly, you don't write the facts of the library case. You don't do that. It's included in the rule proof. Yeah. And the rule proof is one sentence. So let's go back to my presentation. So we're going to set up the outline, which is basically what I did. Then you're going to skim the file. I'm going to show you how to do this, but it's just basically going through the file, not reading it, definitely not reading it, but just looking for things that stand out. If there is a big piece, thanks, Sam. There's a big piece of text. I'm just going to read the first line of each big paragraph that I see, especially in a transcript. So skim the file, just get a sense of what I have to see if it gives me any of the flavor of what's going on. And then the big thing, and this is where people tend to get hung up, is on skimming and reading the library. So and the reason I say skim is you're going to skim until you identify a certain thing, and then you start reading. So if you have statutes, I just read the headings of the statutes just to know what are the statutes dealing with. Most of the time, if you have statutes, they're going to be written in an easier to understand way or broken down way better in the library and the cases. Not always, but often. So I just read the headings of the statutes, then I go to the cases, and I just identify with the cases. I just say, okay, I see if they usually just start with facts. And if it's a facts, it's going to be a fact paragraph, and I skip it. So I read the first line of each paragraph until I get to the procedural history, And then that's when I start reading, and I'm looking to identify rules, and I'm looking to see the court's analysis of those rules. That's what I'm looking for, because I'm going to use the court's analysis of the rule to draft the rule proof. So I'm going to do that. So we're identifying, we're saying, okay, when I read it, get to a case, what issue do I use this case for? Does it go to issue 1? Does it go to issue 2? Does it go to issue 3? Where does it go? Or does it go to 2 issues? Sometimes that happens. So also when I'm in step 4, I am not trying to generally like have a very thorough understanding of the rules and what did the court do. I do that in step 5. So I'm just trying to deconstruct it, just like rip it apart, right? It's like when I do a puzzle, right? Which I don't really do, but I like the analogy. When you do a puzzle, how you like put the edges together, putting the edges together or like the perimeter is step 2. And then the next steps, especially step 4, is like when you take puzzle pieces, so you're like, okay, there's a dog here, there's a tree here, there's a sun here, right? If you look at the image and you put your piles together, that's what we're doing in step 4, is saying, where do each of these things go? And you will use, if there are statutes, you will use at least some of the statutes. If they give you a ton, you're usually not going to use all of them, but you will use some. Every case that they give you, you will use. If there is a case within a case, it's a little bit different if there's a case within a case. If that happens, then you will have, if you have a case within a case, then depends if you will use it. It depends on how in depth they go into the case. If they spend a lot of time talking about another case within your case, that is basically them giving you a second case to use. So then you're going to absolutely treat it as though it was its own freestanding case, and you're going to grab, if there are rules, you're going to grab those, and you may use it to draft a rule proof. If they just have like a very tiny reference to a case with like a clause, then you don't use it. I generally don't use it in that case. Maybe in a perfect world, if I wasn't in 90 minutes, I would use it, but I don't use it in this context. So assign the cases to their appropriate issues and identify where to draft rule explanations or where to draft your rule proofs. If you have an issue where they don't, like, let's say they have you talk about, is there liability for this issue? And then does the defense apply, and you have to go into the damages that are available. Let's say that none of the cases really talk about, they don't go in depth about whether the defense applies. They just give you the rule. So if the cases don't discuss one of the issues, then you're not going to do a rule proof there. Or if the issue is just really straightforward and obvious, then you're not going to do a rule proof. So just as a heads up. And we're really going to go kind of through step 4, not all the way. Then after you're done with that, then you're going to do step 5, which you're just going to type in the rules. And when I'm typing them in, I'm trying to understand what they mean. And I'm going to draft my rule proofs. And for me, the understanding of really how the rule works generally comes when I draft the rule proofs. Maria, I think I'm going to you need to type that in the Q&A or send it to me as an email, because it's going to get lost in the chat. So draft your rules and your rule proofs. You have about 15 minutes to do that. And at that point, when you're done with step 5, you're at the 45-minute mark. And right now, what you should be doing is you should be timing yourself at each step to see where you're at. In my book and in my class, with my model answers, you see where I'm at each step in the process. You see after step 4, this is what it looks like. After step 5, this is what it looks like. But you should also keep track of your timing. Keep track of your timing so that you can identify if you take too long, if you don't finish in time, or you're running out of time in the analysis and your analysis is very short, when the analysis is the most important thing by far. It's truly the most important thing. You need to know the rules, you need to know what happened in the cases so you can use that information. But the points by far are coming from the analysis. So you need to make sure that you have the most time for that. And if you're running out of time there, you need to know where in the process are you getting hung up. So keep track of your time. And it's just, you have a timer going, just be like, all right, I'm moving on to the next step. It's this time, and just take note as you go through it. And there is time to fix the stuff right now on the PT. You just got to practice it. You really have to practice it. After that, you read the file. And so, you don't just skim the file right in step 3. We're going to come back in step 6 and we're going to actually read it in depth. Then we're going to write our analysis, and you're going to proofread, time permitting. In all actuality, if you are someone that runs out of time, I would skip this. I would skip step 3. I would skip the skim of the file. And honestly, I almost never have, and I'm really like, right, I should be incredibly good at doing PTs, and I am. And I don't usually have time to really do a proofread. I will really take like a minute and proofread my substantive headings, and that's about it. So just as a couple of little time tips there. All right, you guys ready to practice this a little bit? Yeah. So let's do it with Hughes. I'm gonna do it with Hughes. And we will be sending out my model answer of Hughes tomorrow when we send out the recording. So please don't, I just ask, my team will get overwhelmed. Please don't ask for the email. We will send it out as an attachment tomorrow afternoon. I promise it's already queued up and ready to go. So that goes out tomorrow, like midday. Just FYI. So, okay, now let's get to this. Let's get to this. All right. So you see that I have here, I'm going to go to a new page. This is kind of what it's going to be like when you're in the exam. You're going to have your materials and you're going to have your space to write the answer. A little bit more space on my computer, possibly. Just as a heads up, you guys can use a desktop or a laptop. So, use the biggest monitor that you can possible, but there are no external monitors allowed. You can't even don't even have anything connected. It should be completely self-sustained. All right, so let's get into this. So here it's two applicant from, so the state's attorney. So it looks like my boss, we work in the state attorney's office, so the prosecution. All right, it's the state v. Hughes. So it's a criminal case. So defendant, Sebastian Hughes. Nadine, yes, I do think this is part. For those of you asking, I do believe that this PT is part of the 2-month schedule, but it's not assigned until much later if it is. But you can also replace one of the PTs in the schedule with this one if you're going to do this to practice, which I do suggest. So defendant Sebastian Hughes is charged with murder after he fatally stabbed his uncle, Peter Galt, during a dispute over a Corvette car engine. Defendant asserts he acted in self-defense. A centerpiece of our case against defendant is a recorded statement defendant made to detectives while he was in the hospital recovering from a stab wound inflicted by his uncle. Defendant originally moved to suppress the statement based on a failure to be given Miranda warnings. The judge ruled in the state's favor on that motion. Defendant now argues that the statement was not voluntary and therefore should be excluded from his trial. The court decided that this new motion does not need to be briefed, but the court does want oral argument. Please draft the oral argument I will give in opposition to the suppression of the statement. So I'm not highlighting anything here. I'm resisting the urge just in case you're not able to. Our success depends on our ability to marshal the facts. Do not start with a statement of facts as you would if you were writing a brief. Rather, weave the specific facts into your argument as they relate to each of the elements of the controlling law. Attached are the transcript of the recorded statement and a portion of the transcript where the court refused to suppress the statement on Miranda grounds. While you are not to address the Miranda issue, the court's characterization of the interview may be helpful to your argument. One thing I just want to mention, I'm getting messages from a bunch of people about the highlighting. I know that you will not be able to highlight in the mock exam, but to me, it is unclear yet whether you will be able to highlight and highlight in multiple colors on the actual exam. That should be addressed by the state bar by their meeting next week. So you should be going to that session. I cannot go, but I think it's going to be recorded and available, and I will watch it. But that is something that hopefully will be addressed by then, and I'm also going to email them. But I'm going to show you what to do today in case you can't highlight. How do you deal with that? So first, I want to identify all those things. So this is a closing argument. This is not a closing argument. This is just an oral argument. Fine. So this is persuasive. And then audience is the court. The product I'm preparing is an oral argument. The organization, they didn't give it to me. I know that we're dealing with the voluntariness of the statement, but they didn't give it to me. So organization, not given. And the special instructions is to no statement of facts and no Miranda. So that's what I would be just making a note. And if you can't, highlight or whatever, just take these notes and you're going to delete them at the end. Then I'm going to do, I don't know my headings yet, but I'm going to do an oral argument. So oral argument, introduction, argument, conclusion. I'm going to put those in. And I don't know what my issues are yet, but they do tell me basically what we're going to say. is we want the court to deny the motion to suppress the statement. So I'm going to just say, the reason that the defendant is arguing that the statement should be suppressed is he's saying that it's not voluntary, so it should be included. So I'm going to argue that it was voluntary. So the statement defendant gave was made voluntarily, and as such should not be, I don't want to say should not, should be admitted in trial or at trial. And that's all I can really say so far. I don't need to go in deeper than that, especially this early on. We don't really know anything more than that. And then I'm going to do a quick conclusion. For the reasons established above, the statement was made voluntarily, and as such, the court should admit the evidence and deny defendant's motion to suppress the statement. That's it. Now I got to figure out what my headings are. So we're going to now we're going to do a little bit of the skim. I'm just going to make a note of anything, and I generally don't like to type out notes. Just me in general. I don't like to type out notes of the facts. The problem that I find with that, and this is why I hope you will be able to highlight, but even then it's not a big deal. The problem is if you start typing out notes, you start typing out a ton of notes. You're not just going to be real slim. So then I just want to sort of note what I have. So I have a transcript of the pretrial hearing where they're dealing with Miranda. So I just am going to read the first line of each paragraph. So let's first deal with defense counsel's motion to exclude on Miranda. Your Honor, defendant moves to exclude the statement made. Okay. Oh, this is the pretrial hearing. So yeah. And I see that they mentioned Mincy v. Arizona. Fine. That stands out to me because it's italicized, so it stands out. Okay, does the state stipulate to these facts? We certainly do not stipulate to the allegations. So, and one thing I also look at, and this is helpful, is when I know that I'm on the DA, right? I work in the DA's office. So defense counsel, this is going to be what the defendant argues. So you're going to use this. You're basically going to argue against this. And the DA argument, this is what I'm going to use in my argument. So when I'm doing my analysis, I am going to be, I'm going to be using the facts here that that the DA made in my analysis paragraphs, and I'm going to use what defense counsel says for counter arguments. One little note on counter arguments: you will have them in every single PT, period. Doesn't matter if it's objective or persuasive. You're going to have at least one, and ideally 2 counter arguments. So here we have the pretrial. So in here, they're talking about Miranda, and then they talk about Mincy. And I just see here that this is talking about the voluntariness. Hey, and then here's a transcript of the actual interview. This is the thing that is being contested. So good evening, Mr. Hughes. I'm Detective Ray. Okay, if me and Peter Galt, he's dead. Mr. Hughes is my partner. Okay, so this is, the cops. I've got tubes in both my lungs. This is the defendant, and I'm a little drugged up, but yeah, okay. So he's got tubes in his lungs. He's a little bit drugged up. Okay, we need to interview you. Our job is to come in when someone passes away. Okay, so we're starting the interview with Mr. Sebastian Hughes in the surgical observation. Okay, so it's like he's had surgery. Just for our record, I want to describe what I see. Okay, can you tell us what happened? I got to call my mom. Okay, so I received a phone call from my mom's brother, Peter Galt, this morning. Okay, I heard my mom crying in the background. I feared for her safety. Okay, I stopped at my work locker and placed an 8-inch wrench, heavy. And then I see there's somebody come from cardiology comes in. Okay, and then big paragraphs. Peter and my mom were standing in the driveway in front of his van. We argued at first, then things got wild. Eventually, Peter knocks me to the ground. Okay, so what happened then? I bent down and tried to pick up the wrench. Peter said, "You're not going to do anything with that." Okay, so then they get in the fight that leads to the uncle being killed by the defendant. Peter ran to the back doors of his van. I thought he was going to grab a knife or something. Okay, I'm sorry. I guess I missed where your knife comes into the story. Oh yeah, I guess I forgot to mention that I got it from my work locker. So he initially says he grabbed a wrench, and then later it comes up that he also got a knife. So I'm like, this guy is, is he really forgetful or what? I realized I'd been stabbed only when I saw blood all over myself. All right. And then I know this was all self-defense, man. If I hadn't stabbed Peter. So he's talking about self-defense, and that's it. And that's it. That's a skim, right? And we're not marking it up. We have one case in the library. We have one case here. When you have one case, there is often going to be a case within it. So that's one thing. Two, if the PT is testing you on an area of law that you are familiar with for the purposes of the bar exam. So we do know coerciveness under the Fourth Amendment, Fifth Amendment, under due process is testable on the bar exam. It's part of criminal procedure. Given that, it's usually going to be the PT itself, the file in the library, maybe a little bit more dense. If it's an area of law that you're totally unfamiliar with, like reinsurance, usually the materials are going to be slimmer because it's going to be more difficult for you to understand it. So, like we saw this in the July 2024 exam. It was a pretty intense file and library, and it was dealing with murder. It was dealing with a second-degree murder charge. So, and it was, people were like, oh my God, there was so much in there. And yeah, that's normal. So just to kind of give you like a little bit of mindset, like, expectation setting. Okay, so let's get into this. So defendant Gerson Perdomo was involved in a single car accident. Okay. After a night of heavy drinking, that's just fact. So I'm not doing anything. I'm not even reading it. Defendant based his defense on the contention that the other surviving occupant. So here, I'm like, are they getting into the facts or are they getting into the procedural history? It kind of looks like it. So whenever they start talking about the procedural history, that's when I start to pay attention. And remember, I'm also trying to figure out my organization. This one, you're going to see that they give it to you pretty easily. But if they didn't do it like I'm about to show you, then you look for words like, first, we must decide whether this, then we must decide that. So when they'll often like number the issues for you. If they don't do that, you just look for where they switch from rules and then they apply the rules to analysis. And then if they get into another set of rules, that's usually a new issue. So look for alternation between rules analysis. They can do that multiple times. A really good example of that is the July 2017 California PT, which is called US v. Davis. You'll see them do that. So this is where I'm going to start reading. Defendant based his defense on the contention that the other surviving occupant, Marco Quinones, was driving at the time of the accident. Defendant moved pre-trial to exclude the evidence of the inculpatory statements he made to the police officers. Near the end of the interview, defendant admitted he sometimes smoked marijuana and then said, maybe that day I was smoking. I'm not going to mess with you guys. I was driving Marco's car. Defendant argued that admission of his statements violated his Fifth and 14th Amendment rights to a fair trial. He claims it was error of constitutional dimension to admit statements he made to officers who interrogated him in the ICU of the hospital while he was recovering from surgery and heavily sedated with narcotic pain medications. Defendant suffered severe traumatic injuries to his chest area. Several of his ribs were fractured. He underwent emergency surgery to remove his spleen. He also had some bleeding in his brain. So they're telling us like what happened, right? They're giving us a lot of facts, but it came after the procedural history, so I'm reading it. I don't stray from that process. 4 days after the accident and defendant's surgery, medical personnel in the ICU finally granted Officer Laubischer and his partner permission to speak to defendant. Medical personnel directed the officers to keep their discussion brief. Around 6:30 a.m., which to me, I'm like, that's early, the officers interviewed defendant in the ICU. The interview was tape recorded. Defendant was lying flat on his bed, recovering from the splenectomy, broken ribs, and head injury. He was in obvious pain. Defendant had received his last pain medication 5.5 hours earlier. He was still connected to IV solutions and monitors. He had been on a vent since the surgery, but this device had been removed the day before and he was breathing on his own. Defendant's speech was slow and deliberate, but not slurred or overly raspy from the intubation. The officer's questions were also slow, subdued, and deliberate. The interview, with numerous pauses, lasted approximately 20 minutes. The officers questioned defendant about the events occurring before and after the accident. Defendant answered responsive to the officer's questions. Most significantly, according to Officer Jensen, who was present and later transcribed the tape, defendant admitted he'd been driving the car when the accident occurred. And then they go to, so here they're talking about the specifics of the case, and they're just giving facts. It's not analysis. But then they go to a broad statement that you can apply to anything. So the statement is involuntary if it is not the product of a rational intellect and free will, Mincy v. Arizona. The question posed by the due process clause in cases of psychological coercion is whether the influences brought to bear upon the accused were such as to overbear the petitioner's will to resist and bring about confessions not freely self-determined. So here, there's a rule, And this is like overarching, right, about voluntariness, which applies to everything here. So rule I'm going to get from, this is per, I'm just going to make a note like here, it's page 19, and I might write, bottom, just to like get where it's from. Generally speaking, if you do have the highlighter, I'm just going to highlight it. And I highlight my rules pink. So I'm going to highlight my rule there. And then they do more rule, and you see how they number it, right? So that's going to give us our organization, right? When they number things like this, you have to read it and be sure. You need to check that it's the organization, but it is here. So in determining whether or not an accused's will is overborne, an examination must be made of all the surrounding circumstances, including one, the characteristics of the accused, including such factors, and I said I'm not going to highlight, as the defendant's maturity, education, physical condition, and mental health, including mental acuity, and two, the details of the interrogation that indicate coercion, which include the length of the interrogation, the location, the interrogation's continuity. Additional factors that might indicate coercion include whether the officers dominated or controlled the course of the interrogation, whether they allowed the defendant to tell his story, then asked follow-up questions to clarify the details, whether their questions were open-ended and neither aggressive nor particularly accusatory in nature, and whether there is evidence that the officers had or drew weapons or otherwise employed threatening or intimidating interrogation tactics. So first, I'm like, oh, wait, I need to put in my headings. So I'm going to just put in here, the characteristics of the accused demonstrate the statement was voluntary. And then B, the details, I'm just pulling it from here. These are my issues. The details of the interrogation demonstrate the statement was voluntary. And this should be statement. I only really try to correct headings if there's typos. And then as I talked about earlier, each section can have, should have rules, may or may not have a rule proof. Often they will, especially when there's only two issues. Analysis, there's usually going to be several analysis paragraphs, but I just put the A as a placeholder for all analysis. If you have a counter argument, the counter argument, and then your conclusion. One thing I want to point out here is that where they say additional factors, blah, blah, blah. When I first read this, I thought there was a third issue. I thought I should talk about the additional factors. When we looked here, the surrounding circumstances, they just broke it up into two. They broke it up into characteristics of the accused and details of the interrogation. So you just needed to do two. But if you had set it up as three, it's fine, not the end of the world at all. You can just have it as a third section. But once you get into it, you're like, oh, this is really part of issue two. Another tip I want to give is just with respect to evaluating which issue is more important. One thing I want to point out here is that they talk about this issue first, right? The characteristics of the accused. And we'll look at how long this issue is. And you see that they go in and give a really long discussion on Mincy. So they give you basically an entire case within our case. So you're going to do a rule proof of Mincy. And you're going to do, and the rules are going to come from Perdomo. And it's really like page 19 to 20 there. And then basically the same thing here. So I'm going to put in the rules, and then they give us a whole other case here. But I just wanted to say that I'm going to have a section on each of these. Now, if you look at the amount of the library that is devoted to each issue, that is a hint as to where the points are. So here, characteristics of the accused is like basically 2 full pages, and details of the interrogation is basically 1 page. So it looks like the first issue is bigger. Still got to save time for the second issue, but it looks like the first issue is bigger. The other part is there's more to talk about, it looks like, in the first issue, but for the second issue, the rule is quite a bit longer. So, they may be actually, when it comes down to it, I think they're fairly closely split, but generally speaking, when there's more of the library dedicated to one issue as opposed to another, that's a hint as to how you need to manage your time. So I just want to throw all that out there. That's all we have time for today. Quick little reminder, if you are going to, let's see, we have for everybody that is here live, well, first I'm going to stop recording and just say thank you to everybody that came here, and then I'm going to give you your promo code. remember to sign up for the free workshops that we have coming up. And also we have it's not too late to do the PT course. We have the PT book. There was enough time for you to make really good use of that. And you should definitely join us for the checkups that we have. And the PT, there's two PT ones. One of them is this Sunday, and I'm going to teach the review after the fact. All right. And now I'm going to pause. Thank you for joining us live. And thank you for everybody that's going to watch it afterwards. Give me just 1 second, hang out here for a second.